It is my pleasure to assist you today as moderator of our webinar. On behalf of our organizers, I am thrilled to have 540 participants registered for our webinar today. We have court leaders, technologists, justice sector professionals from across Ukraine, Europe, the United States, and many other parts of the world. I am also mindful that today is the 4th anniversary of Russia's invasion of Ukraine, and ICA wishes to stand in solidarity with the people of Ukraine. Today's webinar focuses on a topic that is reshaping court administration everywhere: the role of artificial intelligence in enhancing effectiveness and addressing personnel shortages. Courts are being asked to do more with fewer resources, and AI is emerging as a tool that can help us meet that challenge while preserving the values that define justice systems: fairness, transparency, and human oversight. Over the next 90 minutes, we'll explore real examples of AI already in use, the opportunities and risks it presents, and practical frameworks for responsible implementation. The International Association for Court Administration and Pravo Justice regularly collaborate on a variety of webinars and the development of educational programs for court professionals. To welcome you today, I'm pleased to present 3 dignitaries, including ICA President Ms. Pamela Harris, Deputy Head of State Judicial Administration of Ukraine, Mr. Leonid Saplinenkov, and the EU judiciary expert, Mr. Volodymyr Chaban. To begin, Ms. Harris will address us, and you may know Ms. Harris as the former state court administrator of the state of Maryland in the U.S. She is a fellow of the National Center for State Courts Institute for Court Management. She's also served on the board of directors at the National Center for State Courts. And internationally, she has been very actively involved with rule of law initiatives in many countries, including Argentina, Brazil, El Salvador, India, Morocco, Russia, Sri Lanka, and Ukraine, and has spoken internationally on strategic planning, court and case management, specialized courts, and association development. She also serves on the board of the International Institute of Justice Excellence at The Hague. Ms. Harris, welcome, and we look forward to your welcoming words.
Greetings, colleagues and friends from around the globe. On behalf of the International Association for Court Administration, IACA, it is my pleasure to open this webinar, presented in collaboration with the State Judicial Administration of Ukraine and the EU project Pravo Justice. We are certainly grateful for this continuing partnership and, most importantly, for the leadership demonstrated by our Ukrainian colleagues in advancing innovation, especially under the challenging times with which they are faced. The speed at which AI is changing the world is changing the paradigm courts have relied upon for decades, if not centuries. At the same time, public expectations for accessibility, efficiency, and transparency continue to rise. As Mr. Boeing indicated, courts once again are being asked to do more with limited resources, all while safeguarding the foundational principles of fairness, independence, and accountability. AI, when responsibly designed and carefully governed, can serve as a powerful tool in so many areas, thereby reducing routine functions and allowing court professionals to focus more fully on substantive work. Lately, I have often heard people say when presenting a document or an idea for consideration, they cheated and used AI for assistance. Characterizing AI assistance as cheating overlooks the reality that AI will soon be part of nearly every professional process around the globe. Our task is not to resist its presence, but to define clear standards that safeguard integrity, authorship, and accountability. Nevertheless, innovation in the judicial environment must always be guided by principle. The introduction of AI raises many essential questions. How do we ensure transparency? How do we protect sensitive data? How do we guard against bias? How do we maintain meaningful human oversight? And how do we develop regulatory structures that evolve as the technology evolves? Of course, there are many other questions to be answered, but these are practical governance challenges that court administrators and judges across the globe must address thoughtfully and deliberately. During the next 90 minutes, we'll hear from speakers who are actively engaged in implementing or working with AI initiatives in their countries. They will share experiences related to regulatory frameworks, generative AI applications, data protection safeguards, and measurable improvements in efficiency. Our goal today is not simply to discuss technology, but to explore responsible innovation that strengthens court operations while preserving public trust. In closing, thank you to our partners, our distinguished speakers who have volunteered their expertise today, and to all of you for joining us for this important conversation. Thank you and welcome.
Thank you, President Harris. We appreciate those comments very much. And next, I'd like to invite to the podium Mr. Leonid Soplennevkov, the Deputy Head of State, Judicial Administration of Ukraine, responsible for digital development, digital transformation, and digitalization. He was appointed to the High Council by the High Council of Justice in March of 2024. He leads the modernization of the judiciary's IT infrastructure, including the development and implementation of the Unified Judicial Information and Telecommunications Systems. So welcome, Leonid. We're glad you're here today.
Дякую. Шановні колеги, шановні представники Міжнародної
Thank you very much. Dear colleagues, dear representatives of IACA, dear judges, it's my pleasure to welcome you at this webinar, which is dedicated to a very topical issue of the use of AI in court administration. We are here today to talk not only about technologies, but about how these technologies should be and can be used properly. In the modern world, technologies, the use of technologies is not an exception, but rather a necessity which contributes to greater efficiency and to greater public trust in the judicial system, which is particularly important for Ukraine, which is in the middle of the full-scale war, and Ukrainian judicial system needs to make even more efforts in order to ensure proper administration of justice, maintain high public trust, and deliver results. Court administration implies management of resources, human resources, financial resources, infrastructure. This is an everyday work, everyday routine, which can be supported by the use of modern technologies, including artificial intelligence. AI helps analyze large data, better manage human resources, contribute to team building, and it is important to underline that we are not talking about replacing people by machines, but rather about having an auxiliary instrument at hand to be able to perform better. In the European context, the development of e-justice is one of top priorities. In the European Commission guidelines on improvement of efficiency of justice, they state the huge role of modern technologies and digital solutions in particular. For Ukraine, which is on its European integration path at the moment, it is particularly important to follow these guidelines and to make sure that that digital solutions are being implemented. It is important to remember that any changes are possible only if there is synergy, if there is team involvement, once there is clear delineation of roles and allocation of tasks within teams. Artificial intelligence has all chances to become an instrument which empowers managers and gives impetus to organizations. In the context of code administration, it means transfer from passive management to proactive management, from reacting to problems towards predicting problems. It is also a chance to set up a greater framework for the protection of personal data, for processing data, etc. In the meantime, it is important to make sure that the use of AI does not undermine the key principles of justice. The technologies should serve for better delivery of court services rather than to degrading them in any manner. It is valuable for us to be able to attend such webinars with the participation of our international partners and colleagues, because such events contribute to greater exchange of best practices, of best solutions and experiences. We are at the entry point to a new era of modern technologies use in court administration. I truly hope that we will manage to do it in a proper manner. I'm again very much grateful to the organizers and to all the participants for your interest, for being here. I wish us good discussion, and I hope that in the aftermath of the webinar we will come up with some new ideas and solutions for the benefit of our organizations. Thank you.
Thank you very much for taking your time to join us this morning, Mr. Stepelnikov. We appreciate those words of welcome and glad to be part of this program today. And next we have Mr. Volodymyr Chaban, who's a judicial reform and component lead for the EU Pravo Justice project. Volodymyr has been working for the past 3 years with an international technical assistance project supporting Ukraine's judicial reform and institutional capacity building. Since January of 2024, he's been heading the judiciary component at the EU project, Pravo Justice, focusing on reform of judicial governance bodies and the selection procedures for judges of the Constitutional Court of Ukraine, and key priorities on Ukraine's EU integration path. So welcome, Volodymyr. We look forward to hearing your comments.
Дякую, Кевіне, за презентацію. Вітаю, шановні колеги.
Thank you very much, Kevin. Thank you for making a short intro on myself. In the first place, on behalf of EU Project Pravo Justice, I would like to welcome everybody at this event. I can see some 340 participants attending the webinar, which is great in my opinion. Now, going to the point of my speech, I would like to state that from the moment of the very first moment of the full-scale invasion, Ukrainian judicial system has had faced multiple challenges. So the goal was to make sure that justice continues being administered properly despite all the difficulties and constraints of war. Not only we managed to maintain the judicial system on track, but the judicial system continues developing, introducing new technologies, and it is not about prestige or about just giving a good image, but it is about the survival of the judicial system in the time of war. And I'm proud to be part of the international assistance project which is supporting the Ukrainian judicial system on the way. The leadership within the Ukrainian judiciary belongs to the Supreme Court of Ukraine. The Supreme Court was among the first judicial institutions in Ukraine to start working with AI. We also have the All Ukrainian Association of Court staff, court apparatus employees, which is our long-term partner. They have recently come up with the guidelines on AI use in court administration, which is currently being spread out among Ukrainian courts. So we have been supporting the webinars like the one we are having today, because we understand that in order to have progress, in order to again survive in the harsh conditions of war, Ukrainian judicial system needs to have some adaptability and to follow some best solutions from all over the world, from European countries, but also from the US. I know that in the US there are various instruments, like modern instruments, including AI-based instruments, which are used for court administration, for delivery of judgments, even for delivery of judgments. So we would like to learn about such solutions and to somehow implement them in our country. We are also looking forward to having some nationwide framework for the use of AI in court administration and delivery of justice, following the example of the US, of the UK, and some other countries. So in the light of the above, I would like to express our deepest appreciation to IACA for being there for us, for sharing your experience and best practices and standards that we've been implementing in our country. Thank you for supporting our development and thank you for being our partners.
And thank you, Volodymyr. We really appreciate you taking the time to join us, and welcome our participants this morning. We're looking forward to this collaboration very much. And now for our main event, the role of AI in court administration, enhancing effectiveness and addressing personnel shortages. We're very fortunate to have distinguished speakers from Ukraine, from Singapore, and the United States, who are going to take the rest of our time to share their experiences, their lessons learned, and forward-looking strategies. And I encourage you to listen with an eye toward what is transferable to your jurisdiction. We will have a bit of time, I believe, at the end, where we'll welcome your questions and invite you to use the Q&A function to submit your questions ahead of time. But right now, what I'd like to do is just briefly introduce our four panelists, and then I will turn it over to them to take it from there. First, we're going to hear from Bohdan Krejcienko, who's a board member of the All Ukrainian Association of Court Employees and chief of staff at the Anti-Corruption Court. Mr. Krikolenko has a master's degree in law as well as a master's degree in finance, public administration, and international and European law. He began his career in 2005 in the Ministry of Justice of Ukraine, where he worked in the Secretariat of the Government Commissioner for the European Court of Human Rights, where in particular he coordinated the implementation of the decisions of the European Court of Human Rights. Bohdan, welcome. We look forward to hearing from you in a few minutes. Following him, we are going to hear from Dr. Rasim Babanli on the generative AI in the database of the Supreme Court legal positions. He's going to present us with a live demonstration. Rasim is a Ukrainian lawyer who served as the first deputy chief of Secretariat of the Supreme Court in Ukraine since 2023. In the Supreme Court, he's responsible for analytical work, international relations, and communications. And he created the legal position database of the Supreme Court, which utilizes AI and most recently generative AI. And from Singapore, we have Mr. Ken Hui Tan, who's the Chief Transformation and Innovation Officer for the Supreme Court of Singapore. And we appreciate that Ken has stayed up rather late for us to join us. It's late at night in Singapore right now. But in his role, Ken looks after the transformation, digitalization, innovation, and technology plans of the Supreme Court, the state courts, and the family justice courts in Singapore. He has also been involved in related law reform work like the COVID-19 Act in 2020 and the Courts Reform Act of 2021. And he manages the Courts of the Future work plan for the judiciary. So again, Ken, welcome, and we're glad you can be here with us. And our fourth panelist is Mr. Michael Navin, who's the principal court management consultant at the National Center for State Courts here in the U.S. Michael leads technology initiatives within the Technology, Architecture, Planning, and Security Division. He has more than 20 years experience in court administration, and he specializes in applying emergent technologies, especially artificial intelligence, to improve the efficiency, access to justice, and public trust in the courts. Since joining the National Center in 2023, Michael has directed national AI strategy and readiness projects. He's developed governance frameworks and advised courts on the AI first initiatives. And with a lineup of panelists like this, I think we're all going to learn something valuable today. So without further ado, I would like to turn the slide screen over to Bohdan, who will share his slides and start us off for our discussion this morning. And again, to all of our panelists, thank you very much, and we'll look forward to hearing from all of you shortly. Bohdan, please go right ahead.
Yeah, hello everyone. Thank you very much, Kevin. Before I will start my presentation, a few words about the unique format of this webinar. First of all, thank you, International Association of the Court Administration, to President Harris and to Chief Administrative Director, Mr. Bolin, because this is a unique, it's a not first webinar in cooperation of our great partners in Ukraine, I mean European Union project Pravo Justice, but this is a unique representation of the colleagues from the very big different time zone. Then we know that Michael have 6, if I'm correct, early in the morning, can have 10 p.m. in the evening, and here in Ukraine we have 4 p.m. And for me, it's a big honor to together with distinguished colleagues from Ukraine, US, and Singapore to talk about this very important, very relevant topic, especially in this unique day. As you, Kevin, mentioned, today is the fourth year of the full-scale invasion of Russians against Ukraine, and this is our answer that we are with protection by our army, by our defenders. We here in Ukraine talking about the developments, about new modern tools. This is our big answer to the aggression that we will defend, we will stand, and we will win. And each and every Ukrainian will continue to do their professional job on daily work. So here I will go directly to my presentation, and I will switch into Ukrainian because the big majority of our audience is from Ukraine. And as we agreed, you allow me to speak in Ukrainian. I shared the screen. If someone can confirm that it's works.
It's working.
Yeah, thank you so much. Отже, колеги, далі.
So, dear colleagues, now I'll be speaking in Ukrainian because the contents of my presentation all in all is about Ukrainian experiences, about Ukrainian frameworks regulating the use of AI, the algorithms and tools of AI in courts. Therefore, I'd like to draw your attention to the fact that it's a common framework, that is the SOP, Standard Operating Procedure, or the frameworks for the SOP that we have developed together with the colleagues from the All Ukrainian Association of Court Employees, our civil society organization, and the majority of members of our association are also here with us today at this webinar. So we had been working on that for quite some time in 2025 with the support of our reliable partners, EU Project Bravo Justice. And very soon it will be fully available, the text of this document. And today I have this unique opportunity to present it to a wider audience, to present what we have developed. Our work started with the first framework that was taken into account. That was our decree, the decree of the Anti-Corruption Court, by which we have approved the fundamentals of the use of AI in courts. Right now, it looks like a basic and even to some extent primitive document, but the SOPs that I'm going to be covering today, it's about the development of the next layer of the regulative frameworks. I will be using this abbreviation SOP. Its purpose is to establish the principles, terms, and definitions and frameworks under which the court staff and the courts can use AI to support the court administration. So that's a document that can be approved by internal local regulations in your courts or in other state institutions in the justice sector that will consider it feasible. The key terms and definitions that we suggest to implement in our document have to do with the definitions of what AI is, what generative AI is, what AI system is, who is more interested in that. It can be local, just scaled up and trained in court. What are prompts? That is some terms of reference, it's a task that we pose to the software that are out there available today and that are being developed every single day. Mr. Leonid Sapelnikov mentioned of AI literacy. That's a must for us. It's a new framework for the future that we have to master. And that is what we speak of in our document a bit. The primary areas where the AI can be used and admissible, those are automatization of administrative processes, such as systematization of the draft documents, generating sample documents, determining the schedules for the staff, and allocating these schedules among the staff members, and some elements of document management. The second part of the use are information support to draft code decisions, that is analysis of case law, looking for some relevant precedents. I suppose my colleague Rasim will give you real practical examples of how such tools can be used. Also, researching the legal norms and their application. It's analysis of big data sets that can shorten the time span that will be spent on analyzing such huge data sets. Also, analysis of evidence, preparing analytical materials, all that is used in court staff area. Improving the interactions with the court trial participants. That can be online AI consultants that are used in different spheres, and a lot of spheres are using that in banking sphere and in other spheres, and we can use that also in our judiciary for the automated answers to typical questions, to give consultations on basic procedural issues regarding the relevant legislation in different areas, and the translation of the documents, ensuring the availability of such proceedings for people who have no command of Ukrainian. All the documents can be translated fast in several languages simultaneously to have such case files translated into different languages. So other areas is processing of large data sets, statistical information, trends and patterns in judicial sector and case law, and seeing such trends, as well as depending on the caseload and the intensity of the numbers of the case files, where there are trials, we need to be able to forecast and ensure due resources for the administration of justice. Our next major section of the SOP is principles for using AI, such as legality and ensuring human rights, because those are some fundamental elements, and everybody understands the importance of lawfulness when working with different software solutions, and not to cast doubt on the outcomes of our work. Priority of human control is a must, because any findings by the AI have to be checked, analyzed, and verified by a human. And as far as we speak of the judgments, they have to be only ruled by a human. When we use the AI algorithms, we also need to be transparent about that. And the frameworks that are being analyzed, or the stages of work in courts, can call for different software solutions, and we have an obligation to openly mention that and to say that we use it. The fourth principle is non-discrimination and fairness. Here, we have no right to make use of some negative factors, such as the work of the AI. The fifth principle is confidentiality and data protection. That is an issue of primary importance that has to do with uploading data either in local solutions, as I mentioned. There are some local solutions within structures. Maybe over time it will be inside the judiciary or open solutions who everyone knows of, ChatGPT, Claude, Copilot, and others that are used is so we need to understand that if we input some data, we must remember about our internal regulations of the country that ensure the confidentiality and the data protection. Next principle is responsibility for the use of AI by a person, by a human, and the results of such implementation. Then subsidiarity. AI may not perform the key function. AI algorithms are only the tools that support the functions, and they do not substitute the key decision-making by the judge, either individually, either by a single judge or by a panel of judges. Therefore, adaptability and the approaches to using AI that we have to use, we need to look into the goal, into the objectives and aims, and everything that I have already covered before. Usage rules and practical requirements. I'll try to be speaking faster because we don't have that much time, and then maybe in Q&A we will also be able to come back to that. So there must be certified training for colleagues who are going to use AI in their daily work. As far as confidentiality and confidential information is concerned, the external tools that is uploading into some uncontrolled server processing of the sensitive data is inadmissible. And when we speak of AI, we must depersonalize any information that we upload into the system. We must ensure human checks. That is what I have already mentioned as well, that it is a must.
Speaking of cyber hygiene and AI literacy, here we need to remember about the necessity of trainings, about the necessity of application of technical safeguards, and about incident reporting. So we need to be mindful of all the above. We should be mindful of the fact that anything produced by the AI should be double-checked by the person. Two-factor authentication should apply when using AI solutions. Regular updates of antivirus program software and other updates should take place on regular basis, and if anything suspicious is identified, respective specialists in your IT department in the respective courts should be informed. And to end it, to basically summarize it, we should say something of red lines about something which is completely prohibited when it comes to the use of AI. Court decision or parts thereof cannot be taken by AI without proper human control and final approval by judge. The same applies to processing of personal data biometric data, social, ethnic, religious, and other characteristics. Now, I will probably speak about some general things which are truth not only for the court system. So no massive biometrical data should be processed using AI. Behavioral assessments cannot be exercised using AI. And finally, last but not least, some conclusions and some perspectives for the future. It is absolutely advisable to adopt the SOP I've been talking about as a recommended internal standard in each court to be followed by all the court employees and hopefully it will be so in the near future. In this slide, you can see a picture which was generated by AI. Unfortunately, it is available in the Ukrainian language only. My apologies to the English speaking colleagues. I will not get into very much details on what is in the slide. Let me just sum it up, express my appreciation for your attention, and hand it over to the moderator.
Mr. Bohdan, thank you very much for that great presentation. I think you covered a lot of important details that any of our court partners exploring AI need to really think about carefully. I especially like the red lines because they are so important for us to remember. I think there are going to be some questions for you, but we'll come back at the end after each of our panelists move forward. And I'd like to invite Dr. Razim to please proceed with sharing his screen and moving forward with the next part of the presentation.
Добрий день, шановні колеги. Дякую, Кевіне. Дякую.
Good afternoon, dear colleagues. Thank you very much, Kevin. Thank you very much, dear organizers, for having me here in the first place. I cannot but state in the beginning of my intervention that today marks the fourth anniversary of Russia's full-scale invasion of Ukraine. We are having a lot of commemoration events taking place all over our country, and I am proud of my country and my people for standing up to this aggression and for standing still until today. So thanks to those who fight on the battlefield and those who implement the military agenda, we have this opportunity to talk on different topics which are of no less importance for our country. So coming back to the point of our discussion, every time a lawyer encounters a difficult question, a difficult issue to solve, he or she usually refers to the existing court practice in order to find out whether any similar solution had ever been tackled before. However, it is quite complicated to go through the whole massive of existing case law, of existing court practice in order to find something which would be relevant for a case at hand. And thus, the idea that we had together with Bravo Justice Project back in 2020 consisted in providing lawyers with a handy tool facilitating work with large data using modern technologies. The idea consisted in providing lawyers with the possibility of a full text search of court decisions. Imagine you are a lawyer, you have a case, you have a claim, and then you have the possibility to upload your claim in a database. Click the button, and the system comes up with relevant court practice of the Supreme Court correspondent to the claim that you uploaded. So as I told you, we had that idea back in 2020. It was put in practice in 2021, and at that time there were technical possibilities to actually put our idea in practice. Today such possibilities and opportunities are even greater. So based on our ideas, we came up with a vision of how artificial intelligence and digital technologies may be applied for the purposes of court practice. The thing is that the Supreme Court justices in Ukraine deal with some 2,000 cases weekly, which means that tracking the court's own practice is quite challenging. That is why it is so important to have such an instrument as the legal position database at hand. It was created back in 2021 and updated in 2025. I will show you now what it looks like. So we are now on the home page of the legal position database. You have a description of certain positions. Here you have the headline, which basically reflects the opinion of the court on a particular issue. Then you can see a subheading with a more detailed description of what the case was actually about. Besides, you can immediately have access to the full text of the ruling. The ruling is anonymized. It is publicly accessible. By the way, the legal position database is fully accessible for open public, so any of the participants, regardless of the country of stay, may have access to this database. Now, speaking of the search engine, they are quite basic. You may exercise a search by words. For instance, you may indicate a deed of gift and have access to respective legal positions or legal opinions on the deeds of gift. Now you can also exercise search by text, so you may just copy a whole decision or part of a decision, then paste it in the search line, and then the database will come up with relevant court practice. According to our assessment, search functions quite well. I will not get into details, but as an analyst, I can assure you that the search engine is quite good and fast. Besides, there is a possibility of exercising search by a hyperlink to a court decision. The thing is that in Ukraine, we have the unified register of court decisions. So once a decision or a ruling is signed off by a judge, it gets into the unified register. The decisions in the register are anonymized, so no names, no personal data. So imagine you are willing to find relevant court practice of the Supreme Court corresponding to your current case. So you can copy a hyperlink, insert it into the search line, and the database will show you the relevant results, and you will have an opportunity to find out what are your perspectives in your particular case. So that was about how to exercise search. However, starting from 2025, a new feature started to be available, which is producing legal positions. So previously, everything was done manually by an operator who would read through the decisions and come up with a description with the headlines and subheadings. But starting from 2025, the operators may use artificial intelligence in order to produce legal positions. So we may take a particular decision from the court register, copy and paste the hyperlink, and then we choose create a new legal position, and then you should click the button create a new legal position using AI. You may indicate the necessary number of signs. I've chosen 70, and then you actually click the button, you wait for a short while, everything is happening right in front of your eyes. So as you could see, less than 10 minutes, it took less than 10 minutes for the database to come up with a legal position on a particular court decision, based on a particular court decision. And I, as an expert, can certify good quality of the legal position. We actually tested this tool. Some 100 legal positions were produced in testing mode and then reviewed by assessors, and the average score was 8 to 9, which is quite a good rate. So this makes life of operators much easier, saves time. So this stage is, however, considered by us as an intermediary stage. We started by creating a search engine. We proceeded with creating this feature of producing legal positions using AI, and we are thinking of the next step, such as, for instance, generating large data which could be of use for colleagues, for fellow lawyers, judges, and other legal professionals. So we stand on the position that AI cannot replace judges, but we are absolutely in favor of the idea that artificial intelligence may become a very good assistant to judges, facilitating them to dedicate more time to some important things other than producing legal positions. I'm very grateful to Bogdan for inviting me and for giving me this opportunity to speak in front of you. I think it is important to talk about opportunities offered by artificial intelligence in the legal field, and I hope that my speech would be an inspiration for colleagues both in Ukraine and abroad.
Thank you very much, Rasim. We appreciate that presentation, and it's always helpful to see a live presentation in terms of how some of these AI functions can assist in various ways with our courts. For some of our webinar participants, we know there was a little interruption with the interpretation. We think we have corrected that situation. And again, thanks also to our interpreters for their excellent help with providing this in 2 languages simultaneously. So thank you for that. Next on our presentations, before we get to a little Q&A time, I'd like to invite Mr. Ken Hui Tan from Singapore to come on. One of the things that we've learned over the last few years as courts have begun to experiment with AI and the applications of AI is the importance of being able to see actual implementations that can be done and how they work. And Ken has been very generous with his time in terms of sharing some of their work in Singapore and in other jurisdictions. And Ken, again, I appreciate your participation today. We look forward to your reflections on AI this morning. So please, the floor is yours.
Thank you very much, Kevin. Again, I'm very grateful and glad to be here and to join you all to discuss something which is very important to the legal industry all around the world. I don't purport to have perfect answers. The only thing I can say is Singapore is an exceedingly small jurisdiction, and we have been fortunate that it is a little easier for us to do some of the experimentation just because we are such a small country. I start off because of an outline that was proposed to us to talk a little bit about some of the current state of AI integration that we have done in Singapore. And there are 4 areas that I will address in turn briefly. The first is on speech to text transcription using AI technologies. This is something that we've been working on for many years. We have recently reached a point where we are starting to make this available in selected cases to parties for free, so that parties can log in their own device and follow along according to what the AI says has been picked up by the microphones. So I must say I chose this screenshot very carefully because I deliberately left in some of the mistakes that are made by the AI transcription software. So Donna, that you see in the second line of recognized text, is actually Your Honor. All right. And even the last line there, gonna before my little friend proceeds, is actually Your Honor, before my learned friend proceeds. So this was deliberately chosen by me to show that however good the technology is, and we think we have used some of the best transcription engines that are available. However good the technology might be, it is still not perfect, and it would still give us errors like this. But nevertheless, we think it is useful for lawyers to be able to have this if they are not willing to pay for the full-scale human-driven transcription possibilities. So I've mentioned some of this already. I'll leave this slide available to be eventually distributed to participants. Secondly, I talk a bit about e-discovery or evidence review. And this is an example of something that we could do with in-house tools available within the Singapore government. We can load up some of the materials available in a particular corpus of emails, and we're able to query that entire collection of evidence. So if I ask the AI to gather for me all available information about the San Jose property purchase and give me the answer in a table, it is able to do that in a couple of seconds. So sometimes people ask me, how do we know that this is 100% accurate? The reality is, even if I ask a trained lawyer to do this work, even if I ask a young associate to do some of this collation work and this tabulation work, how am I sure that he or she has gotten it 100% correct anyway? So it is something that is a good starting point, and we think it is useful for us to be able to have these tools in our back pocket. I give two other examples here as to how we might want to be able to talk to the evidence and then to find out certain pieces of information either on the court's own motion, or the court may choose to want to query a particular aspect and then ask the parties after that, can you address the email of 13th of May, which neither of you have brought up? Can you please let us know what your thoughts are, whether it is significant to the case? I also mentioned summarization, and this is something that we think also works reasonably well. In another case file, we provided the materials in the case file, and then we asked the AI to take the arguments of one party and the arguments of another party and to juxtapose the corresponding arguments in a table. Because we are providing this material to the AI, we find that hallucinations are much more easily controlled because we can actually ask that the AI provide answers that are grounded in the materials that we provide to the LLM. We think that these tools may be able to help judges prepare for hearings instead of manually reading every page in a large case file. They can get a quick overview as to what the case is about and tease out more as the hearing goes on or as they dig deeper into the case. We have also done what we consider to be helpful for our litigants in person. We've done work with a US startup, Harvey.ai, and what we have done in that area is we have tried to use generative AI to help us improve the user experience for our self-represented persons who have cases before the small claims tribunal. So I have listed here some of the areas that we had thought of that we wanted to use AI to help self-represented persons, and we've worked on some of them. Some of them are in our next phases of implementation of this collaboration with Harvey AI. I move on quickly to talk about the limits and the need for human oversight. And I am very gratified to hear and to understand that many other jurisdictions, including Ukraine, share our concern that we cannot leave or abdicate decision-making to the AI, and there still needs to be very good human oversight. In that connection, we have come up with what we call an approximate traffic light typology, just to help us think a little about whether this is something we want to do or this is something that we don't think we want to do, at least not yet. So firmly in the red zone, which we try to represent with a red traffic light, we would say asking AI to help us in decision making, right? For an AI to tell the judge, yes, you should find in favor of Alice instead of Bob, we would stay very far away from building AI that specifically addresses those possibilities. We also don't think that it is particularly helpful for us to build AI that would help lawyers or parties predict outcomes, to say, oh, you have been assigned this particular judge. Based on what we know about this particular judge, Charles, we think that you will fail, or we think that you have a 60% chance of succeeding. So we are not at all eager to pursue those use cases, and at least for the foreseeable future, those are firmly in our red zone. At the other opposite end of the scale would be the things that we think are pretty much in the green zone, and that would include evidence review and summarization technologies that generative AI seems to be fairly good at. In the amber zone, which is an area where we say we will proceed, but we would be extremely careful, and we would do this with a lot of guardrails. We would say that if we're going to use AI to help us draft legal documents, we would think that it's a possibility, but we would want to proceed extremely carefully. And we may not want to allow the end user, especially the self-represented person, to directly access the LLM. Any interaction we think would have to be very carefully calibrated and curated so that it is as testable and verifiable as possible before we allow people to use it. And the last bullet point there is on access to justice use cases. We had considered general purpose chatbots to allow laypersons to find out their legal rights and obligations. Suffice it to say that we do not think that that is safe to deploy at this point in time. So we have not used that directly to be used by laypersons. Instead, our access to justice use cases are very carefully controlled, like our Harvey collaboration, which I spoke about a little earlier. In terms of other forms of regulation of AI, we have regulation applying to us at several levels. For internal users, we think it's very important that we have training for judges, court administrators, so that they know what they can and they cannot use. They know what they can or cannot load into an AI system, and they know what they should be using it for and what they should not be using it for. If the material that they want to get AI to assist in is of a certain sensitivity nature, then there might be a need for redaction effort. So if the sensitivity is beyond what the AI is rated to cope with, we would insist that the users redact the material before they release it into the AI. We also have issued guidance to court users about how they might use AI. We have decided not to whitelist technologies. Instead, we have focused on responsibility, and we have stressed to users that they are responsible for whatever they eventually produce in court, and they cannot hide behind AI to say, I didn't write this, the AI helped me write this. Finally, Singapore agencies, including the courts, are also subjected to whole of government controls and approval mechanisms before we can use AI products. I hope that these are interesting ideas or experiences from sunny Singapore, and I look forward to a robust discussion shortly. Thank you very much.
Ken, thank you for that great presentation. I found it very interesting the way you use the traffic lights as a way to provide some guidance, quick guidance for us that are looking at it. And I'm going to be interested to see how your thoughts on access to justice chatbots might compare with and be different from what Michael will tell us a little bit about with some experiments in the US, because it seems to me that there are more aggressive efforts in some courts in the US, even though perhaps we ought to be looking more carefully at the guardrails that you discussed. So I look forward to this. We'll hopefully have some time for some questions when we come back. But right now, Michael, I'd like to turn the floor over to you and have you share your slides. And we look forward to your comments next. So please go right ahead.
Well, welcome everyone. I'm glad to kind of bring up the end of this, the last session of this. Just a quick few things about the National Center for State Courts. We're a leading authority on court modernization in the judiciary, not only in the United States, but also internationally. And our work expands research, education, consulting, and technology integration. A couple of the things, our mission is really to improve justice through leadership and innovation, and we support courts with tools for better governance and performance and public service. And internationally, we help courts modernize and align with global best practices, but at the same time tailoring them to the laws, the regulations, the practice, and the culture of the court that we are working with. It's been touched on significantly in the prior 3 sessions, but I think it's very, very important to talk about that before you really talk about AI, that you talk about the governance and the ethics. Under the EU AI Act, the AI in the judiciary is considered a high-risk entity, even though there's an exception to that in the sense that administrative tasks, which is mostly what we'll talk about today, that I'll talk about today, administrative tasks are kind of exempt from that. It's still important to be very deliberate so that you continue and maintain that public trust. In protecting fairness and due process, AI can unintentionally replicate bias and uneven outcomes. And so governance makes sure it ensures that there are that due process is followed. It's not a convenience, it's a requirement. The court's credibility depends on transparency and explainability. People must understand how decisions are informed by AI tools. Risk isn't only operational, it's constitutional when it comes to the courts. Governance structures must address and assess impact on privacy, access, and equality. And finally, courts must be able to answer the question, who is responsible when AI informs or potentially automates a process? Governance defines that chain of accountability. Who monitors, audits, and corrects when there's an issue? And the National Center for State Courts has recently come out last fall with an AI readiness guide for courts that really builds on 3 pillars. One is building the foundations, AI governance, guiding principles, internal use policy. It's very heartening to see the presentation that Bodan gave, talking exactly about those things that are the foundational aspects of where you're going to go with AI, developing those guiding principles that really hit exactly where this AI guide basically comes into effect. Looking at fairness, making sure that the internal AI use policy is developing both guardrails, but also avenues for innovation as well. Data governance, very important. If your data is bad, your AI is going to be bad. So you need to make sure that you have a structure of data governance as well. And this framework holds up on that. AI literacy strategy. Every day when I wake up, I think I hear a new term dealing with AI. So how do you come up with a strategy to keep up with that ever turning literacy that comes out of AI? And then we actually come through and help you look at how to choose a first AI project, and then walk through the important aspects of implementation, change management. How do you get your staff ready for AI? How do you dispel or work through some anxiety that your workers and as well as the public might have about AI? What do you do when you need to start looking at whether you want to build or buy an AI product, and how to work, if you decide to buy, how to work with a vendor or a solution provider? And then finally, the third pillar, post project feedback, a cycle of what lessons learned did you do after that first AI project, and where do you go from there? Keep the momentum going to build off of that to another project. And then we have within that framework a case studies of various courts across the United States that have implemented AI. A good example of this is a project that we're working on right now with the state of Idaho and their judicial branch, where we are looking at both of that AI and data governance together and helping them develop a plan in implementing both of those aspects. And this is based on that AI guide, readiness project assets, building cross-functional governance teams about education, stakeholder engagement, the technical assessment, conducting stakeholder engagement and training within the courts is so very, very important. And overall, aligning AI and data governance efforts with the long-term strategic goals of the court, of the judiciary, so that it can start becoming part of the actual question whenever something new comes up. And how do we implement AI with this as the ultimate goal years down the road? Now I want to go through some of these examples of use cases within the courts in the United States. And a lot of these are not overly complicated. This is a good example of human resources in a court in Texas, where they use ChatGPT for job descriptions and performance improvement plans. They simply start off and they wanted to use ChatGPT to readjust job descriptions. Job descriptions are kind of an ever-changing document based on skill levels needed and changing because of technological changes. And by starting off and using ChatGPT, this court found that it really reduced significantly the description of job description development down by 60%. The same thing with performance improvement plans. They are no longer taking days, they are now taking hours. So a significant efficiency and time savings with just something as simple as ChatGPT use. In the District of Columbia courts, Washington, D.C., a court was spending considerable amount of time developing we're considering amount of time processing invoices. And even though they had a system, they had to take each piece step by step. So they developed an AI bot that automated some aspects of the process within their system. Still had a human in the loop, so as the term is, at various aspects in order to make sure that everything was going okay with the processing. But this had, once it was implemented, it had a significant amount of time on time constraints for the staff. Instead of the staff spending 16 hours per day between 4 staff, it was reduced down to 4 hours each day with 1 staff. And the thing to keep in mind, the very important piece, is that this allowed additional time for data analysis by the other analysts that they had. So in other words, no one lost their job. It simply shifted them to other work. In Palm Beach County, they have an addition to their e-filing system where they were able to add AI bots to their e-filing system to automatically route certain documents to where they needed to go. If a document came in and met a criteria, that document could be forwarded to a judge. That document could simply be just entered into their case management system or document management system. So it reduced the amount of time of repetitive work that these court users were doing. It reduced filings right now are at about 42% are never reviewed by a human. So then also the 4 times the number of filings processed by a bot than a human. And it's also working 365 days a year, 24 hours a day. This is an interesting thing in Orange County where they're using chatbots. They have a lot of turnover among staff, especially at the entry level. And it was really causing a lot of problems where it was causing constant training of new staff. They were at about 2 to 3 months to train a new employee. They created a chatbot where they put all of their standard procedures and processes for each of their case types out into attached to a chatbot. And then when somebody had a question, they could just enter that question into a chatbot, and then they would get the answer. This significantly reduced training down to 2 to 3 weeks. And it also provided more consistent answers to the public. At the same time, they have another internal chatbot that had more to do with internal processes, HR, employee resources. You could ask the chatbot, how much holiday time do I have? How do I obtain a new ID card? What is the family leave process? You could ask that of this separate chatbot, and it will provide you with the answer. Again, reducing the amount of time it takes to get the answer and reducing the time that human resources needs to spend answering that question. Finally, in Los Angeles Superior Court, they have a couple of public-facing chatbots where one of them is dealing with traffic citations. Someone gets a ticket, and prior to this implementation of this AI chatbot, people either had to email, make a phone call, or go to the court to simply pay a ticket, register for traffic school, or schedule a court date. They implemented this chatbot, and it reduced significantly the wait time at each of those courts. Somebody needs to pay a ticket, they can type in the chatbot, and they will be walked through how to pay that traffic ticket right then and there. A significant time savings for not only the employees, but also for the public. The same thing with jury duty. If somebody needed an excusal or wanted to reschedule their date, they can do that through a chatbot instead of having to call or email or walk down to the court. And it's done within a matter of minutes. A huge time savings and a much needed benefit for the public. Some of the commonalities that we were seeing in all of these, they're low risk and high value. Very important. You don't need to kind of deal with more high risk things. They're all very low value. Most of these also were internal aspects, nothing that the public can see outside of that last one. Reduces error, makes it consistent so that errors don't have to take maybe 5 to 10 times longer to correct. And they're scalable. A lot of these courts started with things that were kind of a small part of their court, but they knew that they would be able to expand to other areas in the court as well. So the takeaways is that AI success starts with readiness, understanding your data, your governance, and your operational needs before implementing the technology. Trust is the currency of the justice system. Governance ensures that we bring AI into operations, we preserve integrity, oversight, and transparency. And also start small. It's okay to start small and then continue to grow. Small wins lead to continued momentum. These 3 principles, readiness, governance, and small wins, are what allow AI to move from a series of projects to a reliable system of justice innovation. You'll get a copy of this presentation, but we have some resources out there that are free for everybody to use. We have a policy consortium. Anything and everything you want to know about AI in the courts, you can find here. You can find anything dealing with how judges can use them, to things on operation, as well as access to justice. The AI readiness guide that I mentioned earlier, you can access that through this QR code. And then we also have an AI literacy path. If judges want to learn about AI and go through a curriculum, they can find a tailored version, a tailored training that is specific to judges. Court administrators, a tailored path just for court administrators. Court clerks, again, very tailored path for them as well. So it's a very good intro to AI in the courts AI literacy curriculum. We also have a sandbox, NCSE sandbox, which is basically a chatbot. Think of like ChatGPT, but it's in a closed environment. If you're just worried about using AI in your work, you can come here and not have to worry about any of the information being put out into the general World Wide Web. You don't have to worry about the data being used to retrain a model. You can just come here and simply practice on how to use AI. So a very good resource that a lot of courts are continuing to use and feel safe using. And finally, I just want to stress the importance of making sure that you ask the question, what problem am I trying to solve? What process am I trying to enhance? This was a viral quote that went out a couple years ago. I want AI to do my laundry and dishes so that I can do art and writing, not for AI to do my art and writing so that I can do my laundry and dishes. Make sure that when you're using AI and when you're looking at using AI, that you're actually solving a problem. Don't get into trying to use AI just to say that you're using AI. Make sure you're actually making the court more efficient and better for the public. Thank you very much. And if you have any questions at any time, you're free to shoot me an email. Kevin?
Michael, thank you very much for that. That was interesting. I really like those individual case studies because it gives us a sense that this is not just a theoretical conversation, but a practical one. And at this point, I'd like to invite all of our panelists to come back on. We just have a couple of minutes for questions, but we do have some rather interesting questions that popped up during the presentation. So I look forward to seeing what your responses might be. But Mr. Bodan, if I could go to you first, please. One of the issues that came up a couple of times, and then other panelists may want to weigh in on this as well, but how do you balance this innovation that we're talking about with AI with the need to protect judicial independence and data security? That seems to be an issue that many are struggling with.
Yeah, thank you very much, Kevin, for your question. It's absolutely a very sensitive question for each and every users of AI tools and AI different instruments. So in each jurisdiction, in each country, we have different internal regulations For example, in Ukraine, we have a number of legislation acts in accordance with policy for protection of data, and specifically on the European continent, in European Union, and in the Council of Europe, member states have numbers of conventions and different regulations which should be used. So it's depend from the part of the world. Also, the national legislation, national laws in Ukraine are build quite a big system of protection of data. That's why during my presentation, I stated that accuracy and depersonalization of uploading information or asking questions in chatbots or in other AI assistants and AI agents should be very carefully depersonalized previous depersonalization of information, and also security, especially in Ukraine, but I believe that it's relevant for any part of the world. Cybersecurity that tries to stolen the data. It's also a very big issue for operation with the data of many private persons. And we have in Ukraine, in my court, we have the policy for data protection and a policy for privacy in our court when we are working with information of such type of information. So I see that we have very limited time, so I will stop here. Yeah, thank you.
All right. Thank you very much for that. That's helpful. Dr. Racine, it appears as though you got lots of interesting technical questions as a result of your demonstration, but some included folks wanted to know which AI language model was being used by the Supreme Court and who determines the level of granularity of the generated summary and conclusion based on the Supreme Court decisions. If you have a thought about that, we'd love to hear it.
Дякую за це запитання. Дякую за запитання. Найкраще з нашою задачею впорались Anthropic, це Claude AI, і ми його використовуємо. На другому місці ChatGPT, він теж, в принципі, справлявся з задачами, але найкраще Anthropic спрацював.
All right. Thank you very much for that. Ken, one of the things that came up in looking at your presentation is a question about whether AI is integrated into court administration for managing resources or information flow. Is that something that's an active part of your implementation in Singapore?
Yeah. So we have studied that quite a bit. Some of the solutions that we think we need are not really in the realm of AI. So, for example, when you think about scheduling of cases, right? Some of the problem statements might include, we have an urgent intellectual property case, it needs to be heard within the next 2 weeks, right? How do I find a judge who's available within the next 2 weeks to take on a 5-day trial? And our research shows that if we want technology to help us with that, it is very doable, but it lies more in the realm of constrained programming rather than AI. So the simple solution is to look for a block of 5 days. But if you want far more complex things, which includes things like, if I reschedule this case away from this judge, then I free up an intellectual property judge next week, and then I have to figure out what to do with the case that was scheduled before that judge. And if you do second order, third order reschedulings, even all those things, our research shows that it's really not in an AI realm to build those technologies. So in terms of tight integration, I would say no, we've not found something that we think should be integrated that tightly that is really in the realm of AI. A lot of the things that are good to do would include automated workflow. So if you know that somebody requires the use of hearing aids in court, the use of mobility devices, then could you then make sure that you automatically assign a courtroom that has the appropriate material? If you need vulnerable witness shielding, can you make sure that you then assign a courtroom that has the necessary technology to do that? Yeah. Thank you, Kevin.
Thank you very much, Ken. And Michael, unfortunately, we've hit our time limit, but I may send something to you there for your consideration, and the National Center might want to look at it. But there were some very interesting questions about how to mitigate ethical risks when making AI or generative AI implementations in courts, and what kind of ethical parameters might have come out of some of the projects that you've worked with. So perhaps after this, we may be able to connect and perhaps put some ideas out on the website. But for all of our participants, I just want to thank you all again for taking the time to be here today. I'd like to thank our panelists for their excellent presentations. They were really interesting to me. And Michael, as you mentioned, getting up every morning, there's always some new term with AI that's coming out, or some new article that's been written, and we're all struggling to keep up with all of that as well. So hopefully this collaboration between ICA and Pravo Justice has helped somewhat with that. We really appreciate the willingness of both organizations to come together and put together programs like this. There were many questions about whether this webinar was being recorded and will be available. It was recorded, and it will be available on the ICA website and perhaps elsewhere as well. Just give us a few days to put it all together, and we'll make that available to you. So with that, I'd like to see if either our Pravo Justice partner, Svetlana, would like to make any final comments, or our president from ICA, Pam Harris, any final words from either of you before we go today?
My only final words after all of that, Kevin, is to thank you for your organizational leadership and moderation of the session today. We all greatly appreciated it. Thank you.
You're welcome. And as a final word to our great interpreters, I know there were a few issues along the way, but being able to make this available to folks in different languages is fabulous. We're very thankful for your great skills, and made it very easy to follow. So again, thank you all. I hope you have a great rest of your day, and we look forward to having you back for another ICA and Pravo Justice webinar in the near future. So take care, all.
Thank you. Thank you so much. All the best to all of you. Thank you.